on a topic that was already referred to several times in the previous panels. I think it's time to discuss the proposed European Media Freedom Act, the EMFA. I'm not going to introduce the topic or the proposed act because our first speaker is going to introduce the act. We're very happy to have him here, Maciej Styczen. I hope I pronounced that correctly. He is replacing the initial speaker, Anna Harold. So we're very happy that he is able to replace her. Maciej is working in the team of Anna Harold. So that is the audiovisual and media policy unit of the Commission's DG CNECT. And as I said, he will give an introduction to the EMFA proposal. Our second speaker will be Tarlach McGonagle. He is an associate professor at the Institute for Information Law at the University of Amsterdam, and he is a part-time professor of media law and information society at Leiden Law School, so we are in fact colleagues. Tarlach will discuss the EMFA from a human rights perspective. And our third speaker will be Oliver Money-Kyrle. He is head of the Europe Advocacy and Programs at the International Press Institute. And he will talk on how the EMFA package deals with the issue of media capture. I will keep it that brief. There will be a possibility of asking questions at the end of the three talks, of course, but because we are discussing a brand new proposal, I would like to give also the opportunity for one urgent question for clarification after each talk, if there is, from the audience. So and other questions from the audience or questions in the chat should be kept for after all presentations. Thank you. You have the floor.
Works and the presentation is coming. Okay, so I will start slowly. Thank you very much for this invitation, and I would like to one more time pass the apologies on behalf of my boss, who is extremely busy today, and she really regrets that she missed this opportunity to present the EMFA package to you today. So I understand that my task is to guide you through this proposal and recommendation. I will try to be brief because I noticed that we had a talk last week, and I noticed that I was supposed to talk for 15 minutes and I talked for 1 hour. So I will really do my best. So this is a very much shortened presentation. And then I will try to start the PowerPoint presentation. No, there is no. Oh, no, it suddenly worked. Okay, super. So as you may know, the package was announced 1 year ago during the State of the Union speech, when President von der Leyen underlined that media services should not be treated as any other business, and there is this strong commitment for the Commission to present a targeted proposal to fill the gaps in our legislative arsenal in the area of media law, and also to respond to certain trends or challenges in the media sector. The idea was to create something that builds very much on the existing pieces of legislation, in particular on the revised AVMSD directive, but also now on the DSA and the DMA package that was just adopted. Last year, of course, these two legal acts were still under interinstitutional negotiations, but the idea was to very much propose something that will build on this selection of measures that EU has proposed or that were already put in place. The Commission had the data on and were aware of on the problems that should be tackled through EMFA because of the rule of law reports that now we already had the 3rd edition that have been covering a selection of most pertinent aspects in relation to media pluralism, and through the reports we've been able to notice the increasing level of interference into operation of media services in the EU, both from the side of public actors, but also from the side of private entities. And in some cases also we noticed that the problems to editorial independence have been coming even from the owners of media outlets, from the media sector themselves. And also this request to act have been many times underlined by many resolutions of European Parliament and through the activities of Council of Europe, that was also calling to take yet another step to advance internal market, but also to progress with regards to protecting media pluralism and freedom. As if some of you probably glanced through our impact assessment that accompanied the package, that presents very clearly the objective of the package. And we are talking here, and this is something that I would like to underline on about the internal market piece of legislation. Our proposal is based on Article 114, that is the appropriate legal basis when the EU legislator wants to approximate national frameworks that which hinder functioning of internal market. And through this advancement of internal market, for safeguarding integrity of internal market, we wanted to promote and foster and protect media pluralism and freedom. But the specific outcomes that we see, I think it's interesting, because you could see that the idea was to really provide to make sure that thanks to the proposal, the entire sector, so both recipients and the media actors, so the business entities and regulators, they could benefit from this new instrument. So the idea is to really provide more legal certainty, both from recipients and for providers of media services, to strengthen regulatory cooperation between media regulators, which is key for ensuring that we have consistent and converged regulatory environment, to foster better quality media services, that news could be produced in an independent manner, and to ensure that there is more level playing field between media service providers. And here I talk both in terms of competition between public service media and private media, but also when it comes to distribution of economic resources to media services, both through state advertising, or for instance, when it comes to audience measurement systems, which also have impact on distribution of economic resources in the media sector. So now, very briefly, keeping in mind that I have probably more 5 minutes left, I will just guide you through the key headlines of the proposal. So I hope this would facilitate a little bit the reading of this act, which I understand might not be a very easy task. The first pillar of the proposal focuses on the rights and responsibilities of media service providers and rights of recipients of media service providers. And here, for the first time in the EU legislation, we propose a new right to to have an access and receive the plurality of news and current affairs content that should be produced with respect to editorial freedom. We proposed a set of rights that would protect media services and journalists from state interference. So, for instance, here is the prohibition of any interference on influence from the state, and specific safeguards that I think are very important for the operation of journalists in Article 4, in particular with regards to disclosing their sources. So here we say clearly that there should be no detention or sanctions for journalists when they don't want to disclose their sources. And there's a prohibition of deploying of spyware towards journalists and their families in unless specific, clearly described circumstances are present that relate to protection of public service. We also have in this part safeguards with relation to protection of media companies from private interference. And here I refer to Article 6, which gives this obligation for media service providers, firstly, to be more transparent with regards to their ownership structure. And here, as you may know, we build very much on Article 5 of AVMSD that already had certain disclosure obligations for audiovisual media services. Now we enlarged it to media services that provide news and current affairs content. And in Article 6.2, there is a novel provision that obliges media companies to take measures that they deem appropriate. So there is this high discretion for media companies in view of protecting editorial independence within their media companies. And these two aspects of Article 6 link directly to the recommendation that was that accompanied the regulation, which provides some sort of practical tool and an open catalog of measures that the media companies could try to implement within their corporate structures. So it's very much invitation and some sort of practical list. So we hope that media companies would be able to draw inspiration from the recommendation, both with regards to the measures related to to protecting editorial independence and integrity, and also with regards to disclosure of media ownership transparency. In recommendation, we also, this is something that we discussed, we have also a small part for member states when we also invite them to work further on media ownership, in particular by better implementing the standards that Council of Europe has been highlighting in its recommendations. The 2 minutes, okay, so very briefly, we have also, as I mentioned, the framework for cooperation and convergence that's supposed to empower media regulators with some formal channels of communication so they can cooperate better, they can communicate better, and they could react better, including when it comes to threats coming from third country media services. This is, of course, a lesson learned from the recent Russian aggression on Ukraine. We established a new board for media services that it's a substantive upgrade of the current ERGA, which has a status of Commission expert group, and the board will be reinforced for its more robust role by Commission Secretariat. We also have, as I mentioned, this light harmonization of rules that are very pertinent for the operation of media companies, in particular when we talk about media concentrations, because we notice that there are many divergences between national legal systems, and in some cases media concentrations took place without any consideration of their impact on media pluralism. And through EMFA, we try to inject into national legal systems this assessment of media pluralism in the context of concentration. There is, of course, a part on online and digital issues related to media pluralism, Article 17, 18, and 19, when we aim to empower media services a little bit in the environment of very large online platforms, but also empowered users to have this right to customize the audiovisual media offer, and to avoid that specific media service providers are in the better position because of their, let's say, financial power, and thanks to this, they could make sure that their content is pushed to the audiences. And okay, and the last part is the tiny part at the end. So as I mentioned, with regards to the distribution of resources, we have a specific article on state advertising when we provide certain criteria that state advertising should adhere to make sure that it's allocated in a transparent and non-discriminatory way. So not to limit the risk that state advertising only goes to pro-government media. We also envisage monitoring tools to make sure that this transparency works well in practice. And there's also a novel provision on audience measurement that builds, in this case, on DMA. And as you may know, under DMA, there's already a provision that gives rights to advertisers and publishers to ask gatekeepers on data related to performance of their content. Here we build and we take yet another step, and we give media service providers and advertisers the right also to get information on the methodology. So they would be able to better evaluate how this performance was on the basis of which formulas this performance was measured.
Good afternoon, everyone. Thank you very much to the Meijers Committee for having me. It's a pleasure to be here. And, you know, I've got a feeling that this is like the opening matinee of a new theatrical production. Definitely the most frequently used chat-up line so far today has been, what do you think of it? So we've just got the ink drying on the DSA and the DMA, and now we've got a new proposal for a new regulatory package, which is going to keep us busy for some time to come. So let's go. I'm going to continue with the metaphor of drama, and I've organized my presentation, you know, as if it was a real piece of theater. So we'll start with the plot outline. We'll start with the act, and somewhat provocatively, I'm going to say, ceci n'est pas un European Media Freedom Act. And then if that's not what it is, what is it? Then I'll look at the scene, but thankfully Maciej has done that very well for me, so I'll be brief on that. I'll stress the importance of broader positioning, and then I'll get to the heart of what I want to do today, which is to examine this proposal and, to a lesser extent, the accompanying recommendation from the perspective of fundamental rights. So to answer that chat-up line, my take on this is that, you know, I recognize that this pushes the boat out. It does improve on the situation that's already there, but I'm constructively critical of what it does for human rights. And as I go through my presentation, I'll look at what's in there and how it is treated in there. I'll look at what's missing, and I'll try to address some of the gaps, gray areas, fuzzy areas, potential blind spots that that Maria Luisa has already adverted to in her presentation. So let's go. Let's see how the drama unfolds. The act. Magritte has a real place of prominence in this city, so I just took this as my starting point. If it isn't a Media Freedom Act, what is it? When I heard the first whisperings about a Media Freedom Act from Commissioners Jourová and Breton and subsequently by President von der Leyen, I got very excited. For me, freedom is a big, bold, brave term. It still is. But what I see in this proposal is not the big silver bullet piece of regulation that will address all of the current threats to media freedom in Europe. Rather, and with your kind permission, I'll paraphrase you from last week because you put it very accurately and eloquently. It is a specific set of rules to address various threats to media freedom and pluralism online. And I would furthermore say that this has been done within EU law and pursuant to the logic of the internal market. So what I'm going to explore from now on is maybe a little bit outside the box, but I just want to stress that I do understand the complexities and constraints of competences, and I do understand the need to shoehorn all of this into the logic of the internal market. So what I will try to do is show how within these logics and dynamics that we can still double down or improve on the fundamental rights aspects. Okay, so that's where I'm going to take it from. Now, thankfully, I don't need to go through this in any detail. And by the way, if you've got questions of clarification, he's already admitted he's got 45 minutes of unused material. So that's where you got to go knocking. And he did it excellently last week. But this is, again, just a quick overview of the different chapters in the proposal for the regulation. The scene. What we've seen in the first panel, and again in the first presentation here, is that we're operating in a very complex environment. And I would say it's a European information, media, and human rights space. And I would also say it's a shared European information, media, and human rights space. And by that, I mean both the European Union and the Council of Europe, amongst other intergovernmental actors. And it's also a shared European regulatory and policy space. So I think it's very important in the first place to position ourselves within the EU. And here I've just got a selection of the, shall we say, more legal regulatory standards, and then underneath a selection of Commission recommendations that are also addressing relevant aspects of media freedom as I see it. For me, maybe useful to clarify, for me, media freedom is about three main components. First of all, it's about safety and security for all the individual actors involved in the media ecosystem. And I think it's important to talk about an ecosystem. It may seem a little bit aloof, as Isa mentioned, but I think there are real benefits from the metaphor because it captures the media in a very complex environment where other media actors are also playing an important role in public debate and public discourse, which is very much at the heart of what we're discussing here today. So the first component is safety and security. The second is what was centrally addressed in the first panel today, namely issues of pluralism and independence of all the actors involved. And that necessarily involves all kinds of questions about ownership, control, influence. And to get back to one of the questions from the floor, I think it was Frederick, how do you deal with dominance if it doesn't, lead to specific implications for the market? Well, I think the metaphor of an ecosystem is perfect for addressing that. And we see all the monitoring work that's been done by the Media Pluralism Monitor and more recently the Euromo about media ownership structures that can keep an eye on relevant developments towards dominance and how dominance works in a particular national or subnational context. So very important to have all of that on our radar screen, as well as the instruments that have to be triggered when certain thresholds or risks arise. The third component, I would say then, is also partly present in this package, and that is notions of quality and ethics and other epistemic values that govern public debate. You know, if we want to communicate with each other, if we want to share opinions and ideas, that information, opinions and ideas, they have to be accessible to each other. They have to be intelligible to each other. And they have to be accessible. We have to be able to judge them. Where are they coming from? Who's behind them? And what is their impact? I love those three expressions. They're not mine. They come from Honora O'Neill. So the accessibility, intelligibility, and accessibility, very much present in this. So they're my three components. And what we see, I think, in this proposal for a Media Freedom Act is a response to a number of the threats that have been emerging in recent times to the media. So one that was correctly identified was threats to pluralism, the opacity of media ownership, the lack of transparency, also notions of beneficial ownership and all these dodgy constructions that hide the real ownership of media companies and cronyism. This is very important ingredient in the media capture dynamics that we'll hear about in just a moment from Oliver. So really, really important things. And we see in places, you know, with references to rogue media service providers and foreign influence sprinkled throughout this text, that there is also a very palpable fear about interference from third countries in the shared information media and human rights space, which we have in Europe. So these are the threats that have, I think, in different ways shaped this proposal, and of course the public service media and their independence, and also the independence of NRAs, national regulatory authorities for the lovers of acronyms. And then I'd just like to draw attention to three recommendations that have been adopted by the Committee of Ministers of the Council of Europe, not as an apologist for their work, or not as a propagandist for their work, but here I think you see that the three components that I've just referred to are nicely captured in the titles and content of these recommendations. We see the Commission using these recommendations in different ways. So to get back to the question that was addressed to Elda earlier, what's the relationship like? I would say it's a normal neighborly relationship. And I think it was Robert Frost once said that good fences make good neighbors. So yeah, you need your fences between the neighbors, but there are also always going to be overhanging branches and weeds and stuff, and you got to work together to deal with them in an efficient way. I don't think it's any different at the interinstitutional level. But what we can see is that the Commission sometimes uses the content of these recommendations, sometimes adds to them, and sometimes, very importantly for the Council of Europe, calls for full and effective implementation of these measures. And here we see, as I said earlier, it is a shared space, and it's very important to be aware of these positional issues. I'll leave it at that for now. My big solution to all of this sounds a little bit abstract, but it is really, really important. And that is that we should be working towards a favorable environment for media freedom. All the best parts of my presentation aren't my own. This one isn't either. It comes from the European Court of Human Rights and its famous Dink judgment. So it's not just a nice metaphor, it's actually a positive obligation for states, for members of the Council of Europe. Basically, what the court has said in this pronouncement is that states are obliged to put in place an effective system of protection for authors and journalists as part of their broader obligation to create a favorable environment for participation in public debate by everyone, and to enable the expression of opinions and ideas without fear, even when they are contrary to those held by the authorities or by a significant section of public opinion, and even if they are annoying or shocking for the latter. All right. So that means in the first place, states have to guarantee the safety and security of everyone participating in public debate. That necessarily includes the media and media actors. And I'd like to just refer back to Ramona Strugario's very eloquent presentation of, the importance of these issues, the importance of standard setting work against SLAPs. This is all a very important part of the ecosystem. And we see through different regulatory and policy instruments that you can operationalize this positive obligation in different ways. That's also, as we heard from Maciej just now, that guidance is given to states so they can pursue these objectives in practical and workable ways. What's also important here is that the favorable environment, and at the heart of that favorable environment is pluralism, independence, free flow of information, and an ability to have robust public debate without laws or other restrictions on public watchdog activities. In the interest of time, I'm not going to go into depth on the content of the 3 recommendations. Happy to get back to it in Q&A, because sometimes these recommendations from the Council of Europe aren't as widely known as comparable instruments from the European Union. Happy to get back to them, but here you can see already from the structure that there are different, they really unpack the issues addressed in their titles. Media pluralism, transparency of media ownership. Here you see the favorable environment coming back centrally. Diversity of media content, regulation of media ownership, ownership, control, and concentration, transparency. And one thing that I didn't really see in the current proposal, media literacy and education. The thinking behind its inclusion in this recommendation is that transparency is a very important tool for ensuring accountability. But of itself, it's not enough. You can have the information, but you have to know what to do with it. Very often that information is presented in a fragmented way, or it's complex information. How do you process it? So very important to have it accompanied by media literacy and education. And nice to see in the recommendation by the Commission that they're picking up strongly on this notion of member states ensuring that there are open, accessible databases on media ownership that are freely accessible online. I'm really speeding now, your chair, to reassure you. And then we see on promoting a favorable environment for quality journalism in the digital age. Note that the title doesn't get sucked into digital quality journalism and what it is. And that's a little question mark that I have about the EMFA proposal, because I see in places passing references to the free flow of trustworthy information, or I see references to quality media service providers. And I'm just wondering then how those terms are going to be qualified in practice, especially when they don't appear in the definitional section of the proposal. One of my constructive criticisms of the current proposal is that it focuses on technological silos, or at least shadows of silos, if I can borrow Isa's phrase from earlier. We're dealing with specific sorts of media service providers, recognizable newspapers, televisions, but in a totally different context, totally up in the cloud, but turned upside down. And in this new ecosystem where we're now operating, we can see that the media and journalists, which are characterized very much in this proposal by their economic and professional activities in the logic of the internal market, they still hold a dominant position in public debate, but all around them, there are lots of other actors contributing to public debate in different ways. Perhaps it's more striking in this slide here, because there you can see a combination of more individual kind of actors and very large online platforms. So it's a very complex and varied ecosystem, and all the more reason to take a holistic approach to it. So in conclusion, what can we do to double down on human rights? Well, I think it's important to look at certain specific provisions in the proposal, such as the rights of users. It's a short, early, and very important article in the proposal. But the rights of users are described as the rights of recipients, which for me is a very passive description of how we use information provided by the media. It doesn't capture the interaction that defines the modern communications environment. Another thing is the emphasis on news and current affairs content, not defined in the definitional section, and agreed, it's a very important thing when it comes to public opinion making and making informed decisions in a democratic society. So it may well be the primus inter pares of content for public debate, but what about the broader range of quality publications and programming, such as cultural productions and output, all very important for the broader opinion forming processes in any democratic society. What about children's programming? And then the rights of recipients or users. I think it's important to ensure that those rights are effective for all groups of users, so including, for example, children or persons with different kinds of disabilities, to name but a couple. I'll leave it at that in the interest of time. Maybe just another thing to throw up one last thing to throw up for the discussion afterwards is these notions of cooperation and control amongst the national regulatory authorities or bodies, and the role of the new European Media Board in and its relationship with the Commission. I think there's an interesting space to be explored there. I thank you for your attention and look forward to questions and discussion.
Thank you very much, Tarlach. Is there a quick question from the audience before we move to the third speaker? No, then we go immediately to the third speaker. You have the floor, Oliver.
Okay, thanks. That's just gonna keep falling off here. Thanks very much. Thanks to the Mayor's Committee for hosting this event, for bringing us all together. Just introduce myself. So I'm Oliver Money-Kyrle. I work for the International Press Institute. We're a press freedom organization, one of those old Cold War NGOs set up, I think, in 1950 in New York. We're based in Vienna. We work on, well, monitoring press, campaigning for press freedom and for improving journalistic standards. I've been in the field for about sort of 20-something years. And as a consequence, I'm not a lawyer. And what does that mean? That means that I'm quite good at identifying problems and seeing what the problems are there, but I'm not so good at identifying the solutions, or rather, I look to our legal experts to find the solutions, and for us to then criticise and complain about those solutions because they don't solve the problems that we want solving. Which brings us quickly on to the European Media Freedom Act. And I'd like to thank the Commission for bringing this forward. It was a really welcome surprise when it was first announced about a year ago. We've been working or pushing the Commission for some time to put forward more, to have more tools than to deal with the issue of what we perceive as something called media capture. This is an area of work that IPI specifically focuses on, I think partly because it's based in Vienna and therefore it has an expertise on the neighbouring countries of Central and Eastern Europe. And the media sector in Central and Eastern Europe is quite different from the traditional healthy media democracies of Germany, the Scandinavian countries, Belgium, of course. And I think that is really important to identify when we look at the challenges facing the Commission and ourselves on how we are going to get this EMFA over the line and against the opposition we're going to find. Because I think the Commission is going to have opposition largely on three fronts, and that would be, well, the member states in which media capture is very strong, Hungary, Poland, other countries. Member states where there is a there is a resistance to the Commission or the EU taking on new powers and overreaching into an area that is not traditionally the role of the Commission, where they say, well, there's no problem here. Why should the EU be telling us how to regulate our media scene? And then there's the third sort of key opposition, I think, which is the sort of the publishers groups, which for those who've been following this issue closely, they've put out very strong statements against the launch of the European Media Freedom Act, which they somewhat imaginatively described as the European Unfreedom Acts, which they have concerns. And I think there are genuine concerns, important concerns that need to be addressed. But I think that their opposition is certainly exaggerated and to an extent protecting other interests rather than their interests over media and the quality of media. Just to rewind, I think it's quite useful just to look at why there is a Media Freedom Act and what the problem is, at least from IPI's perspective, and that's the question of media capture. And we sort of loosely define media capture, or rather politically driven media capture, with other forms of capture, as the use and abuse of government powers or government economic and regulatory levers to gain control over the nation's media. What does this mean in practice? Taking over public service media primarily. You put your people, party loyalists, onto the board of public service broadcasters, and they become part of your communications or propaganda outlets. You only have to look at the Hungarian elections back in April, where the opposition candidate, leading head of the opposition candidacy, was afforded 5 minutes on the national broadcaster in the election campaign. These may be free elections that took place in Hungary, but they're certainly not fair elections. So that's a very, very serious problem. Very closely related to that, I think, is the placing of political allies into regulatory bodies. We've already heard quite a lot about the role of regulatory bodies. You put your political allies in there, and their rulings and decisions are taken in favour of the political party. I think immediately of Club Radio, again, Hungarian example. The Media Council in Hungary banned Club Radio as a year and a half ago. Now, that's one of the most noticeable examples. State advertising funds, again, mentioned earlier, how the state uses or directs state advertising funds to fund its propaganda media often in the private sector, or its pro-government media. Certainly use it as both a carrot and a stick, but to have influence. And generally speaking, I would say to create a hostile economic climate to independent media, to independent publishers. And I think this is a really key issue, because one of the criticisms coming from the publishers to the EMFA is that they think that any sort of regulation will increase costs and restrict their ability to act as business operators. And the big question about media ownership, media concentration, and in maintaining pluralism is the restriction on their ability to consolidate and to make profits. And they'd also claim that there isn't a European-wide economic or media market. We would argue that media capture, if you can media capture creates barriers to quality journalism in countries where media capture has taken place. If you can bring down those barriers, then you can give it a boost to the economic sector of for the media. And we've seen how German publishers predominantly are gradually, or have been, forced out of countries where an hostile economic climate is created. Most recently, I think in Poland, where Polska Press was sold by the German company to the state not owned but state controlled energy giant PKN Orlen. There are other elements to media capture as well. States giving favourable bank loans to closely allied oligarchs in order to be able to purchase media. using the use of state contracts in other industries to finance media owned by oligarchs that have their businesses in other areas. I'm thinking of the construction industry, the finance industry, the energy industry. In Andrej Babiš's case, the former Prime Minister of the Czech Republic, he was a big oligarch in agriculture. There is the introduction of laws to ban broadcasters. So there's foreign-owned broadcasters in Poland. So the PIS tried to introduce what's called the Lex TVN law, which would ban any foreign media with any broadcaster with over 50% ownership outside of the EU. The motivation for doing it allegedly was to prevent Russian disinformation actors or Chinese disinformation actors, but by happenstance, the only broadcaster that would be affected would be the leading independent news broadcaster, TVN, that was owned by the US Disney Channel. It didn't get through, and one of the reasons it was vetoed at the last minute by President Duda, probably because they saw the war coming, and it wasn't a moment to upset their US allies at the time. So that's another example. Other examples in Slovenia, you had the SDS-led government that starved the state agency for 9 months of funding in order to bring that under control. It has since been able to put in its former head of communications in as the sort of head of or the director of the public broadcaster RTVSLO. We've also seen how Hungary is exporting its model through the use of Hungarian capital. So you've had Hungarian companies that have bought up media in Slovenia and North Macedonia predominantly, but specifically Slovenia, but media that are owned by their ideological allies and their political allies within the European Union. And that is why there was also an investigation into the misuse of foreign funds for political campaigning, because this is one way to support a political campaign by funneling money into media which are nominally independent of the political party, but are actually a part of it. And then, of course, KESMA, I think, was mentioned by Ramona. This is the big media foundation where a lot of the sort of Fidesz oligarchs place their I think some 460 media outlets formed under one foundation so that it could centralize the Fidesz propaganda outfit. And that was created, and the government conveniently exempted this merger from being reviewed by the Hungarian Competition Authority. So these are some of the sort of big issues about the EMFA. And whenever we sort of talked to the Commission about this, the Commission said, yes, we need to do something about it, but we don't have the tools. Here we are further down the line, and we've been presented with, hopefully, the toolbox. So how we assess the EMFA, I think one of the key things is to assess, well, does it give the tools to the Commission to deal with some of these problems? The jury's out on that. I mean, I think, there's lots of ambition. The Act appears to be high on ambition, but there are some obvious, quite significant gaps and significant loopholes that is in there. Let's take ownership transparency to deal with at first. So again, in the actual regulation, there is a requirement on media service providers provide quite detailed information in terms of ownership, boards, the structure of the boards, and also the beneficial owners, which I think is the key element. It's not just the name on the company register, it's who's behind that name and what power is behind that name, to make that information available to its audience. This is really, really important. What it's lacking, though, is a verification process. Yes, there is the Centre from Florence, there is the ENO, I think it's EMO or ENO that's referred to as, again, it's a sort of group of universities that sort of are monitoring media ownership across Europe, but these are not institutions, it's not legal institutions, it's not national institutions. So the question there is, who is monitoring this information, who is reporting, who is defining the methodology about media ownership, and what sectors of the media sector they occupy, whether you're looking at media ownership or concentration on the question of platforms or influence or news. These are all complex issues, and this is areas where we hope the board will be able to set standard. I think, Tarlach, you were talking about that, and Isa was talking a little bit about that earlier. There's the question there for the board is, can that set the standards and create a Europe-wide methodology so that these reports nationally make sense? There's no European-wide database for media ownership. In the recommendations, there is talk about that, but it's not in the regulation, and that is a real problem. If there was one thing that I would want to see strengthened in the Media Freedom Act, it would be to have really strong transparency requirements, because it's only with that information that policymakers can make sensible policy. Oh my God, I'm down to 2 minutes left. Okay, well, I'm about a third of the way through. So that's the problem with the media ownership. State advertising. There's a very good clause in here that talks about the EMFA requires public funds for advertising to be awarded according to transparent, objective, proportionate and non-discriminatory criteria through open, proportionate and non-discriminatory procedures. So this is really important. The misuse of state advertising is prolific. It's not just in the media captured countries. This time last year, the Austrian Chancellor, was it this time last year? Yes, it's 2021. Sebastian Kurz was forced to resign for having or being accused of or allegedly misused government funds to buy positive coverage. So it's not just in the source of the usual suspects, it's also in places like Austria. This is a very serious problem. Does this solve the problem? Probably, it probably goes a long way, but there is a strange loophole in there, and that is that it doesn't apply to local authorities with a population of under 1 million. And perhaps we can come back to that in the question of answer about what the consequence of that loophole might be. There is another significant loophole, and that is that state advertising is only one part of it. Media subsidies is another part, and Isa was talking about how common state subsidies are across Europe. What is not addressed is the question of how media owned by oligarchs in other industries are also receive state contracts. So state contracts to build motorways or to build power stations or to, these sorts of areas. And you'll see that in Central and Eastern Europe, a lot of after the financial crisis of 2008, a lot of the German and other publishers left. And who bought up the media there? It was established oligarchs who made very, very wealthy based on their relationship with the state, based on state contracts. Were they buying media to make profits? No, they're buying media to have influence. And because they rely on state contracts, they are therefore very close to the government. So an obvious question here is, why does the EMFA simply not ban media from either applying for or being awarded state contracts in other industries outside of the media sector? That would, with one swift strike of the pen, I think, solve a very crucial issue. That's state advertising. Then just very quickly on the independence of national regulators, we talked about the peer-to-peer cooperation through the board, and I think that's probably very important. There's a very important clause in Article 5 about public service broadcasting, which seeks to strengthen the appointments process, to depoliticize the appointments process for public broadcasters. What I don't understand is why that clause isn't applied to the appointments process for national regulators. It seems to me the same problem, the same issue. Why isn't there the same solution? I don't know, but that's a couple of points. Look, there are other issues we could talk about. There's the question of surveillance and protection of sources. This is very important. There's the very awkward question around Article 17 and the media exemption. We could get into that. I would say that from our point of view as an organisation that represents journalists, we would think, yes, journalists obviously ought to have an exemption from platforms taking down our content, but we also recognise that if you provide that exemption, then you can't solve the problem of disinformation. We would be a lot more comfortable with the clause as it is, where media can self-declare that they are proper media if the publishers were to concede on ownership transparency and other elements. That would make us much more comfortable about that. I'm probably out of time, so thanks very much. Okay.